Hello, friend. In this update, we're going to talk about the recent memorandum issued by the president of the Family Division. In this video, we're going to be talking about the recent president's memorandum on witness statements. The memorandum has been issued by the president of the Family Division due to various breaches in preparing witness statements to a professional standard. The memorandum states that too many witness statements are prepared in breach of proper professional standard. It is clear that this problem is not confined to proceedings in the family court. It has become so acute in the business and property court that it has been necessary to pass a highly prescriptive practice direction, that CPR, Civil Procedure Rules Practice Direction PD 57AC, to seek to deal with the problem. The President does not consider that the family needs an equivalent practice direction, at least not at the present time. However, the Family Procedure Rules Committee will have to consider introducing such a measure if the principles in this memorandum are not observed. The memorandum then sets out the fundamental requirements. Witness statements tell the parties and the court what evidence a party intends to rely on at a final hearing. Their use has the key added benefit of promoting the overriding objectives by helping the court to deal with cases justly and proportionately, including by helping to put parties on an equal footing, saving time at the final hearing and promoting settlement in advance of the final hearing. Witness statements must only contain evidence from the maker of the statement. The statement must be expressed in the first person using the witness' own words. That's Practice Direction 22A at paragraph 4.1. A witness statement must not quote at any length from any document. B. Seek to argue the case. C. Take the court through the document in the case. D. Set out a narrative derived from the documents. E. Express the opinion of the witness. Or F. Use rhetorics. The memorandum then deals with facts, information, and beliefs from paragraph 8. A witness statement must only set out matters of fact and matters of information and belief. Paragraph 4.3 of the practice direction. Paragraph 9, matters of fact include past facts, i.e. events which have happened, close brackets, and future facts, i.e. events which are expected to happen, close brackets. A statement may state only those matters of fact of which the witness has personal knowledge and which are relevant to the case. The statement must indicate the source of any matters of information and belief. Evidence about proposed child arrangements or, in a financial remedy case, about needs will be matters of information and belief. Therefore, where such evidence of such information and belief is given, the source or basis for that belief must be stated. The memorandum now deals with section dealing with documents. A. The statement must identify in a list appended to it what document, if any, the witness has referred to or been referred to for the purpose of providing the evidence set out in the statement. B. The statement should identify or describe the document in such a way that they may be located easily at the final hearing. C. Documents disclosed in the proceedings should be listed by disclosure documents, must not by document disclosed in the proceedings should be disclosed by disclosure reference, e.g., in colon, reply to questionnaire bundle at page 75, close brackets, close colon. Such documents must not be annexed to the statement. D. The requirement to identify documents the witness has referred to or been referred to does not affect any privilege that may exist in relation to any of those documents. Privileged documents may be identified by category or general description. E. Documents in the list which are not privileged, have not been previously disclosed, must be disclosed at the same time the witness statement is filed and served. The memorandum now deals with a section on memory. A person involved in preparing the statement of a witness must not, subject to the next paragraph, in any way seek to alter or influence the recollection of the witness. This is a rule of fundamental importance, breach of which will be serious professional misconduct. However, the memory of the witnesses may be refreshed by showing them a document which they created or which they saw while the facts stated in the document were still fresh in their mind. Any such document must be listed under paragraph 11. Parties should understand that the court's approach to witness evidence based on human memory will be in accordance with CPR PD 57AC, which is Civil Procedure Rules Practice Direction 57 Appeal Cases, Appendix, paragraph 1.3. This states that human memory, A, is not a simple mental record of a witnessed event that is fixed at the time of the experience and fades over time, but B, is a fluid and malleable state of perception concerning an individual's past experience, and therefore C, is vulnerable to being altered by a range of influences such as the individual may or may not be conscious of the alteration. A person involved in preparing a witness statement should keep this very clearly in mind and therefore be wary of categorical statements about past events unless those events are corroborated by contemporaneous documents. The memorandum now deals with length of statement. A witness statement must be as concise as possible without omitting anything of significance. As a general standard, a witness statement should not exceed 15 pages in length, excluding exhibits. This page limit is a statement of best practice and does not derogate from the limit of 25 pages in Practice Direction 27A, paragraph 5.2a, sub 1, which should be regarded as a maximum. Then the memorandum deals with sanctions. The court has a power under Family Procedure Rules 22.1 subsection 2 to exclude evidence that would otherwise be admissible. The court will consider excluding under this rule a witness statement which materially fails to comply with the standards in the memorandum. The court also has power under Civil Procedure Rules paragraph 44.11 subsection 1 subsection B to disallow the cost incurred in preparation of a non-compliant witness statement. The memorandum then deals with templates for LIPs in non-complex private law welfare cases. A useful template for use by litigants in person in non-complex private law welfare cases can be used in those proceedings. Its use in such case is optional but is strongly encouraged. It should be noted that a guide for LIPs, that's LIPs, litigating in the family court will be prepared in due course.